a permit law hidden in the NFA? For years, the battle over suppressors has been framed as a policy debate. Should Americans have the right to own a quiet firearm accessory? Or should suppressors stay trapped under an 80-year-old tax and registration system from the 1930s? But that debate quietly transformed into a constitutional showdown when the Trump Department of Justice reversed its position on suppressors and admitted they are protected arms under the Second Amendment. That changed everything. It forced the Fifth Circuit to confront the NFA directly and triggered a chain of rulings that now drag this case toward the Supreme Court. And unlike past suppressor fights, this one has a clock running. A real person is facing real prison time. Law enforcement staged a raid, prosecutors secured a conviction, and the appellate court refused to wait for the Supreme Court before issuing a mandate. That alone raises the stakes far beyond gun policy. It touches on federal power, the Bruen test, the definition of an arm, and whether a permit system can be disguised as a tax and registration law. In other words, the question is no longer whether suppressors should be legal. The question is whether the NFA still survives the Constitution in a post-Bruen world. If you want to stay informed on developments as they happen, make sure you are subscribed so you never miss the updates that actually matter. Section 1. The case that forced the issue. The case at the center of all of this is United States versus Peterson, a Fifth Circuit suppressor challenge that began as a criminal prosecution, not a public policy fight. Federal agents raided Peterson's home and FFL operation in Louisiana. Prosecutors alleged record-keeping issues, the sale of firearms later linked to crime scenes, and ultimately possession of a solvent trap treated as a suppressor under the NFA. That single item triggered the NFA's tax and registration provisions and led to a conviction. Peterson's defense team moved to dismiss the indictment on Second Amendment grounds after New York State Rifle and Pistol Association versus Bruen fundamentally altered how courts evaluate firearm restrictions. The argument was simple: suppressors are protected arms, and therefore a criminal prohibition requiring registration and taxation violates the Second Amendment unless the government identifies a historical analog consistent with 1791 or 1868 traditions. The district court rejected that argument, clearing the path for appellate review. Three core dynamics emerged immediately. The government hinged its theory on the NFA's registration system, not on historical analogs. The case forced courts to decide whether suppressors count as arms. Bruen's text history tradition test controlled every step of the litigation. That alone made the case dangerous to the NFA. It put the statute under the exact framework that anti-gun states have struggled to survive in recent 2A litigation. RAP. The procedural posture mattered because Peterson wasn't seeking policy change. He was seeking freedom. Criminal cases move faster and they corner the government in a way civil policy suits rarely do. Section 2. DOJ's stunning reversal. While the case initially proceeded under the Biden DOJ, the mid-case transition to the Trump DOJ produced a dramatic reversal. The new DOJ abandoned the argument that suppressors are not arms at all. Instead, they acknowledged suppressors qualify as protected arms under Bruen. That admission didn't end the case, but it detonated the legal landscape. For 80-plus years, federal agencies treated suppressors as accessories, detachable components, or dangerous implements requiring heavy regulation. Now, the very department defending the NFA conceded they are arms. Three major consequences flowed from that shift. It forced appellate judges to confront NFA regulation under the Second Amendment. It foreclosed the government's easiest escape route, denying constitutional coverage. It set the NFA on a collision course with Bruen's history tradition test. To be clear, the DOJ didn't surrender the NFA. They simply upgraded their theory. Their new argument was more sophisticated. Suppressors may be arms, but the NFA operates like a Schwal-issue permit, and therefore it's compliant with Bruen, at least in their view. RAP? That repositioning signaled that the DOJ understands the old accessory argument won't survive at the Supreme Court. The government is now trying to redefine the NFA itself. Section 3. Fifth Circuit's unusual logic. Armed with the DOJ's new framing, the three-judge Fifth Circuit panel adopted the Schwal-issue permit analogy. They concluded that even if suppressors are arms, the NFA survives because it functions as an objective system with defined criteria, limited discretion, background checks, fingerprints, and fees. That analysis shocked most 2A litigators for one reason. Bruen was not a permit case. Bruen was a may-issue case. Justice Kavanaugh's concurrence merely explained that shall-issue permit systems would likely be permissible if they were objective and non-discretionary. The Fifth Circuit extended that dicta far beyond its original domain. from carry permits to suppressors, from state laws to federal taxation, from regulating public carry to regulating possession, from minimal fees to burdensome delays and a tax stamp. Wrap. For the first time, an appellate court essentially declared that the NFA is constitutional not by tradition or history, but by comparison to an entirely different legal category. It was a doctrinal leap, and that leap is now headed toward the Supreme Court. Section 4. The Bruen test meets the NFA. Even anti-gun states have struggled to defend modern firearms laws under history and tradition review. Courts have repeatedly struck bans on magazines, suppressor rules, and carry restrictions when states fail to locate genuine historical analogs. Suppressor regulation has thin historical support. Early American laws regulated gunpowder storage, hunting, firing ranges, and concealed carry not detachable sound moderating devices. The Fifth Circuit sidestepped that history by shifting the fight onto permitting doctrine. Critics argue that maneuver not only violates Bruen's framework, it rewrites it. Key tension points now include: can a tax plus registration equal a permit? Can taxation be used to restrict a constitutional right? Can accessories be reclassified to avoid historical scrutiny? These questions aren't hypothetical. They echo through ongoing litigation involving magazines, pistol braces, and public carry zones. Wrap. Bruen was meant to constrain government discretion. The Fifth Circuit may have built a roadmap for expanding it. Section 5. The prison clock problem. Because Peterson was prosecuted, the case includes a feature civil 2, a litigation lax, jail time. After losing in the Fifth Circuit, Peterson sought en banc review to halt the mandate while he petitioned the Supreme Court. The Fifth Circuit denied it. Then they denied his motion to stay. In effect, they were willing to begin the punishment phase before the Supreme Court could even accept the case. That procedural choice illustrates something Supreme Court watchers understand well. Timing can become leverage in constitutional litigation. 3 consequences emerged immediately. Supreme Court review became urgent instead of theoretical. The case shifted from policy to liberty. Lower courts signaled confidence that SCOTUS might not intervene. Wrap. Criminal posture doesn't just raise the stakes. It accelerates the litigation politics and amplifies the national consequences of delay. Section 6. Suppressors as protected arms. After Bruen, the threshold question in any firearms case is simple. Is the item, weapon, or device an arm? If the answer is yes, then the government must show that its regulation aligns with historical tradition. If the answer is no, the analysis ends before constitutional protection is triggered. For suppressors, this became the flashpoint. Historically, the federal government resisted classifying suppressors as arms, calling them accessories, detachable devices, or mere attachments. The Biden DOJ maintained that stance throughout early litigation. The Trump DOJ reversed it, acknowledging suppressors fall within the broader definition of arms because they facilitate the operation of a firearm and serve a lawful common purpose: hearing protection and safety. Suppressors are used across 3 major domains: sport and hunting, where they reduce auditory damage and improve accuracy; self-defense, especially indoors, where muzzle blast can cause permanent hearing loss; training environments, where injury prevention aligns with basic firearm safety principles. Under Bruen's text-based inquiry, widespread lawful use is a constitutional indicator. Modern ownership numbers reflect that. More than 3 million suppressors are currently registered, and 38 states allow civilian possession. Even anti-gun states didn't ban suppressors, they merely obstructed access. Wrap. Once suppressors crossed the constitutional threshold into arms, the question became not whether they may be owned, but whether the NFA can justify the burden it imposes. That burden is where the Fifth Circuit's permit analogy enters the fight. Section 7. Taxation as a constitutional filter. The core structure of the NFA is deceptively simple. Pay a tax, register the item, wait for approval, and only then receive lawful possession. If that sounds familiar, it should. The government's argument now mirrors the logic of shall-issue carry regimes: objective criteria, background checks, fingerprints, and fees. But taxation on constitutional rights has a complicated history. The Supreme Court has repeatedly rejected tax burdens that suppress fundamental rights. Examples include Grosjean v. Yad American Press Co., 1936. Louisiana imposed heavy taxes on newspapers, struck down as unconstitutional. Murdoch v. Pennsylvania, 1943. License taxes on Jehovah's Witnesses distributing religious tracts, struck down under free exercise. Harper v. Virginia Board of Elections, 1966. Poll taxes abolished under equal protection and voting rights jurisprudence. Federal courts have long recognized that a right priced into scarcity becomes a privilege. Bruen expanded that recognition into the Second Amendment domain. The Fifth Circuit avoided the tax problem by transforming the NFA into a licensing system. But that creates a second problem. Licensing implies discretion and compliance gates. The NFA introduces both and far more than Bruen contemplated. Wrap. If taxation cannot replace historical tradition, the NFA may not survive constitutional review under Bruen, no matter how the government labels it. Section 8. Federal power versus state reality. Suppressors demonstrate one of the most interesting splits in modern gun law. While the federal government treats suppressors as unusually dangerous devices warranting tax, registration, and federal approval, the states treat them as safety equipment. That split functions across three layers. Layer 1. Lawful use. Hunters rely on suppressors to avoid damaging their hearing. Wildlife managers endorse them for environmental reasons, and private ranges prefer them due to noise ordinances. Layer 2. Regulation. Most suppressor owners obtain them through simple state-level possession rules, while only the federal government imposes a stamp, a tax, and long wait times. Layer 3. Cultural context. Anti-gun groups depict suppressors as military gear or assassination tools. But in other nations, including the UK and New Zealand, suppressors are considered polite equipment for reducing noise pollution. This contrast raises constitutional questions. If suppressors align with public health and safety functions, why are they trapped behind an 80-year-old federal stamp program? Wrap. When state norms and federal regulations diverge, the Supreme Court often steps in to harmonize the law. Bruen itself emerged from precisely that kind of collision. Section 9. Supreme Court's pathways. Once Peterson petitions the Supreme Court, the justices will not simply evaluate whether suppressors are useful. They will evaluate the legal architecture. The court has multiple paths. Path 1. Deny review. This leaves the Fifth Circuit's permit analogy intact and would signal tolerance for taxation-based gun regulation. It is also the least likely option given the Bruen framework's unresolved questions. Path 2. Take the case narrowly. The court could accept review solely to clarify whether Bruen's dicta on permits applies outside public carry and whether taxation may regulate exercise of a constitutional right. Path 3. Take the case broadly. The court could delve into the NFA's entire suppressor regime, testing its historical analogs against the founding era and Reconstruction. Path 4. The case as a bridge. Peterson may become one of several coordinated 2A cases addressing the NFA, pistol braces, SBRS, and magazine restrictions simultaneously. Wrap. The court doesn't need to overturn the NFA in full to redefine it. A single ruling on taxation or permits could recalibrate the entire federal framework. Section 10. The stakes go beyond suppressors. Suppressor litigation does not exist in isolation. It interacts with broader Second Amendment challenges now emerging in district and circuit courts nationwide. If taxation can stand in for historical justification, then a state could theoretically use fees, processing delays, or administrative approvals to carve up the right to bear arms quietly and without bans. Conversely, if the court rejects taxation or permits analogies, then several modern gun control schemes collapse instantly. Three areas are especially vulnerable: magazine limits, already collapsing in multiple circuits under Bruen, pistol braces, and SBR classifications, tied directly to the NFA's definitional logic. Sensitive place expansions. Bruen's most abused doctrine so far. The Peterson case also raises a practical question. If suppressors are arms, and if millions of them already exist lawfully, then the NFA looks increasingly like a bottleneck from a technological era that no longer exists. Courts have already recognized that outdated frameworks cannot control modern constitutional reality forever. Wrap. A suppressor case that started with a solvent trap and a raid now serves as a referendum on how far the government can go when regulating a right the Constitution explicitly protects. The outcome won't just affect one man in Louisiana, it will affect how the Second Amendment works for everyone else. The clock just started! The Fifth Circuit's ruling doesn't end this fight, it accelerates it. The DOJ flipped its position, the appellate court embraced a new doctrine, and the Supreme Court now faces a binary choice: allow a taxation-based permit system to survive, or reaffirm that constitutional rights don't require stamps, fees, and delays. As Peterson moves toward the Supreme Court, two questions define the next chapter. Is the NFA a permit system dressed as a tax law? And if so, does Bruen allow that? If you found this breakdown useful or learned something new, Make sure to subscribe to the channel and share this video with someone who cares about the Second Amendment. It helps more than you think and keeps these legal fights in the public conversation. More updates are coming. This one isn't done.